Well, hello and a very warm welcome to our coffee break life sciences startup session and today's session on early stage IP protection. We are Dr. Anja Lunze and myself, Tobias Baus, from Taylor Wessing's Munich office. We are both lawyers focusing on intellectual property, especially patents. And we want to share today with you some of our experiences on life sciences IP, particularly with regard to startups. This applies not only to life sciences, or the IP basics particularly. So even if you're not focused on life sciences, bear with us today. And also, please don't hesitate to ask any questions, either in the chat question function in this program, or please don't hesitate to get in touch with us after the webinar with any follow-up questions. That being said, let's start. So a few years ago, I went for a master program in intellectual property to Italy. And when I told Anja I'm going to Italy, I guess she had this picture in mind, which is only partly true, I must say. I did a lot of research on intellectual property for startups there. And I also learned something about grapevines, like we see here on this picture. So grapevines, they start yielding fruit approximately 2 years after you plant them. And they yield fruit until more or less the age of 20 years. And you can prolong that with a few tricks. And I noticed a patent is just like a grapevine. And you need to have it planted before you want to yield fruit. So that's something we want to talk about today, metaphorically speaking, in today's webinar. And let's stay in Italy, and let me give you a second metaphor. IP is for your company what lavender is for your closet. Once you notice you need it, it's probably too late getting it. So IP not only yields fruit, it also protects your business case, or can do so. And that's what lavender does for your clothing in your closet. So the task for startups really is finding out what IP your company needs, how much, and once again, start early getting it. And that's a second point we want to talk about in today's webinar, in which we will have 4 chapters to give a short overview. Firstly, an overview and types of IP. Secondly, Anja will elaborate why IP at all. Thirdly, what, when, and at which cost does IP come? And we'll conclude with a short summary on pitfalls and takeaways. So let's start with our first chapter.
So I will give you now an overview and types of IP, starting with the question, well, what are we actually talking about today? What is IP? So IP means, of course, intellectual property. So all non-tangible property rights, such as patents and utility models, copyright, which includes software protection and protection for databases, design rights, often forgotten, but quite a useful tool as well, trademarks, of course, and in case of medicinal products, data and market exclusivity. These rights offer exclusivity, which means that you can prevent competitors from using them. This gives your company exclusivity on the market for a certain period of time and is therefore a key element of protecting your business model, as well as creating valuable assets for your company. Further, on the right-hand side, there's also know-how protection. Know-how is only factually protected as long as it is kept secret. Once it is disclosed, even if only accidentally, it is gone. So there might be damages claims against the person who disclosed the information, but you have in principle no exclusivity over competitors. For a startup, it is important to identify your intangible assets and find the IP tools that protect the core of your business. Be creative, also with the use of the legal tools available. In life sciences, the interplay of patents with prolonged protection by SPCs, which are supplementary protection certificates, and parallel data and market exclusivity further helps innovators. The background of these additional exclusivity rights is in order to meet the patentability requirements of novelty and inventive step, it is on the one hand necessary to file a patent application as early as possible when there is not yet a marketable product at all. On the other hand, manufacture and distribution of medicinal products require the grant of a marketing authorization under the relevant pharmaceutical laws after successful clinical trials, which is burdensome, lengthy, and very costly. And you never know whether it works out, of course. Patents expire 20 years after the filing date. This is shown in the lower light blue arrow. If there has been a very long period of testing in clinical trials, the effective lifetime of patents remaining at the start of the marketing might therefore be rather short. SPCs and the data and market exclusivity therefore intend to overcome these drawbacks and try to amortize the innovators for their investments. So SPCs prolong the patent protection for the duration of the process of getting marketing approval for a maximum of 5 years after the expiry of the patent. This is also shown in the light blue arrow at the right-hand side. Additional extensions are possible for pediatric products. The green arrows in the upper part show the parallel data exclusivity, which starts with the grant of the marketing authorization. Currently, there are 8 years of data exclusivity, followed by 2 years of marketing exclusivity. So data exclusivity means that once you received a marketing authorization for a product, any competitor, for example, a generic or a biosimilar company, is prohibited from relying on the data for his own application for the duration of 8 years. Market protection, in addition, means that there is an additional period of 2 years thereafter, during which a competitor, generic, hybrid, or biosimilar company, can already apply for marketing authorization, but they are not allowed to place a product on the market. Here, an extension by an additional year is possible if a new indication for the active substance is approved in the first 8 years and an additional clinical benefit compared to the existing therapies is confirmed in the approval procedure. So having looked at the different kinds of IP and exclusivity rights, we now take a closer look on the IP strategy for startups. And when you look at your business case, there are 2 things to consider in your IP strategy. First, you need freedom of action, in particular freedom to operate. And second, you should build up your own IP assets. For the first pillar shown in the left column, you need to be aware of third parties' IP rights that might affect your business. Third parties might prohibit you from manufacturing and selling your product if it falls within the scope of their patent, for example. So a profound freedom to operate analysis is absolutely key. The best, but usually unlikely result of such an FTO analysis is that there are no relevant third-party rights, so you have green light to go on with your business. The more likely result, however, is shown in the yellow squares. It will be likely that there will be some relevant third-party rights because the world does, of course, not start from scratch once you start your startup, but there have been innovations and intellectual property before. In such case, there's a number of options, from licensing in the relevant IP, cross-licensing, which also then requires that you have already built up some own IP assets, or when you have enough money, buying the other company and becoming the owner of the relevant IP. Another option is to design around. This means to amend your product so that it does not fall anymore within the scope of the protection of third parties' rights. That might be easier for medical devices than for medicinal products, but still that's an option to consider. It would also be possible to challenge the third-party rights if there are good reasons. For example, filing a revocation action against a patent, if you can attack the novelty or inventive step of that patent. This, however, requires sufficient pocket money for litigation, and it also might take quite a while until a final decision. So it's not really in the timeline of a startup company. It might, however, increase the chances of coming to an out-of-court license agreement. If, however, the result of the freedom to operate analysis shows red lights only, the business case should perhaps better be reconsidered. For the second pillar on the right-hand side, the relevant factors to be considered in your IP strategy are why IP, what kind of IP, when should I start protecting my business, and finally, what does it cost? We will take a closer look to each of those questions in the further slides. So, why IP? Well, I think I already said IP is key for protecting your business model from competition, in particular by exclusivity rights, for building up your own assets, and by that to increase the value of your company. But let's take a closer look. So on the pro side, for getting IP protection on the left-hand side of this slide, the first reason for IP protection is, to put obstacles for competitors regarding your own product and beyond. This is key, in particular for life sciences startups, because of the long clinical trial phase. If you invest all the money in order to bring one product on the market, you want to be able to exclude others from using your ideas. Therefore, you need exclusivity rights, like patents, utility models, SPCs, data and market exclusivity, accompanied by trademarks and design rights. The second argument is building a strategic patent portfolio. This means to consider where are your key markets as well as where are your key competitors geographically seen. Do not only think about where your clients are, but also where your potential competitors might have manufacturing sites and supply chains. Further, competitors will notice that you are building up a patent portfolio and consider it in their strategy, because they also do freedom to operate analysis. They will take you seriously once you start building up your portfolio. A strategic patent portfolio also helps you to build up negotiation value and enter into cross-licensing agreements in case there is any relevant third-party IP out there in the world. The third reason for IP is, well, startup funding and valuation. A strategic patent and IP portfolio will also considerably help you to build assets that increase the valuation of your startup, and it will help you to collect investors' funds. And last but not least, monetization of IP. So the intellectual property rights could be monetized even without an own product on the market. So IP adds a security to your business case. IP could be monetized by means of licensing and transfer, for example. In particular, think of the case that the clinical trials should fail and there will be no product in the end. A further aspect to be thought of is the business valuation of the startup, in particular with regard to a potential exit of the founders. Yeah. Are there any reasons against IP protection? Yeah, well, everything in the world costs money. So, of course, one reason to well consider IP protection are the costs. In particular, patent protection is costly, as is litigation against competitors. Nevertheless, as everything costs money, that's not really an argument against IP protection, because you need it, as we just explained, but rather to well consider your strategy. The second argument against IP protection might perhaps be the fact that after the expiry of the patent, the innovation will fall into the public domain, and it could be used by anybody after those 20 years. Or in case of SPCs, after the expiry of the SPC. However, this drawback is perhaps less relevant for medicinal products, as due to the marketing authorization process, most relevant information needs to be disclosed anyway at some stage, but is protected by the data and market exclusivity. The alternative against disclosing the information would be trade secret protection. However, as already mentioned initially, trade secrets will not give you exclusivity rights, and they could only be monetized by know-how licensing. The general danger of secrets is that they are being leaked accidentally or even intentionally. There might be data leaks. There are always unhappy employees talking too much, or unhappy co-founders at some stage. And even if you might have damages claims against them for leaking information, the secret is gone, and you can't enforce it against competitors. So now turning to the next question, what, when, and how costly, and in particular to what can be protected? In general, any innovation that is new, inventive, and technical can be protected by a patent, provided that it does not fall within some few exceptions. Patents could, for example, be granted for medical devices, medicinal products, such as a compound as such, or the new use of an already known compound, which we lawyers call second medical use claims. It is also possible to protect personalized medicine inventions, such as medicinal products for a specific type of patients with particular symptoms, or patients that have already unsuccessfully undergone a particular treatment or particular dosage regimens. Also, computer-implemented inventions are in principle protectable. While software as such falls only under copyright law, as long as there is any technical effect, as the interplay with a technical device is involved, it can be protected. So there is a vast amount of case law that your IP advisors and your IP lawyers should know, and should also know how to navigate it and to get protection for your innovations. When it comes to biologic materials, we need to differentiate between the human or animal body and plants as such. Those cannot be protected. The human body, in the various stages of its formation and development, including germ cells, and also the mere discovery of one of its components, including the sequence or partial sequence of a gene, are not patentable inventions. However, biologic material can be protected if it has been isolated or produced from its natural environment by means of a technical process, even if it was already present in nature. The same applies to an isolated component of a human body obtained by a technical process. So here again, as with regard to computer-implemented inventions, your lawyer should know how to formulate the patent application to get it granted. There are other particular exceptions, in particular in Germany, excluding the protection of any embryo-related use or cloning and the like. Also for diagnostic methods, we need to differentiate. So methods for the surgical or therapeutic treatment of the human or the animal body. So that what doctors do when you go to the doctor, those cannot be protected. However, particular substances or mixtures of substances for use in one of the above mentioned procedures are protectable. So here again, your lawyer should know how to navigate the case law. As a general message, keep in mind that there are certain limitations and exceptions, but with creativity, you can get aspects protected which your competitors' lawyers haven't even thought of protecting. I'm now handing over back to Tobias for the question, when to protect.
Thank you, Anja. So when do I want to apply for IP, particularly for patents? So we have to keep in mind here that we have generally a race against time, a race against your competitors also filing for patent applications, a race against your competitors developing products, which may then, even without own patent application of theirs, have a right to own prior use. And they might be able to use these ideas even though you have a granted patent later. So generally, yes, the sooner the better. However, a rushed application or too early application may have several pitfalls or drawbacks. So keep in mind an incomplete patent application can be a problem for you later, for example, because you forgot the key aspect, or later find out what is the key to your invention, and may have a problem getting a second later patent application to be inventive over your own earlier applications. Or for example, in the case of compounds, you may need experimental data within your patent application for so-called plausibility to get the patent granted. So there's a number of aspects, also considering that we see inventions maturing and products maturing. And the task here may be to find the ideal point in time between your earliest idea of the invention and you're publishing it or you're going to the market. And keeping, of course, in mind the race against time. Now, a second question here on the slide is, if I get data exclusivity, why patent at all? So Anja has mentioned this earlier. We really suggest using or potentially considering using any IP tools available, and patent and data exclusivity here are two complementary tools as they have different scopes of protection. So for example, data exclusivity is really directed to the product you have received market authorization for, whereas patent protection is generally completely independent thereof, can have a technical scope going far beyond your own product, can have a different geographic and time scope, and also has a very different legal approach. So combine the tools available to really increase your chances to secure the market. Now let's talk about money. On the one hand, you need IP to acquire funding. There's lots of empirical evidence that suggests that IP does increase your startup's chances of success and particularly of acquiring funding, while this is case specific and every startup needs an own IP strategy. But just for example, just last year, the European Patent Office conducted a great empirical analysis and found that startups with registered IP have more than twice the likelihood than other startups to obtain seed stage funding and 6 times higher chances to get early stage funding. While this does, of course, depend on specifics of your business case, of the technology, the sector, but for life sciences, more likely than not, you really need IP also to acquire funding. On the other hand, you need funding for IP. There are some, as Anja mentioned earlier, some aspects of IP that come more or less for free, such as secrecy protection. You need a concept and some protection measures, but trade secret protection is more or less for free, and so is copyright, which comes to life basically the moment you create your creative content. Whereas patents and trademarks are, of course, more costly and require an expert registering and filing these applications. So do we have a chicken or egg problem here? How do we go about, given that a startup is just growing, and which one to get first? Our approach here is generally to have your company grow with IP growing in parallel, and thereby resolving this paradox. So have IP on your radar from day one. Start with a basic IP strategy that you can already communicate to investors. As mentioned, some of the IP measures are completely or more or less for free. And then use every round of funding to improve your IP situation and shine IP-wise in the next round of funding, and grow in parallel in both aspects. Now, here's another aspect we want to shortly touch on, becoming more legal, but nonetheless very important. So make sure you have ownership of your IP, which is not trivial in many cases, particularly if you are a university spin-off. So if, for example, the inventors of your IP have been or still are employees of a university, then, for example, on the German employee invention law, that means the employer is the owner of IP created of patents, which means as a startup company, you need to make sure you have the rights to this IP, possibly owned by a university or other third parties. So for IP transfer, there are generally three ways we have shown here of how to get access to this IP. First one would be an IP assignment, meaning transfer of the IP from the university to the startup against a payment, lump sum, or different ways of successive payments, for example. Or secondly, licensing the IP from the university to the startup against various possible forms of payments. And a third option, and this is a very important one, is IP for shares, meaning the university transfers or licenses or exclusively licenses the IP to the startup, and in return receives virtual or actual shares to your company. This is a method practiced quite commonly by lots of universities in different jurisdictions. So this is very case specific. Not every university has the same approach to this topic of IP transfer, and particularly the topic of IP for shares. So the challenge here is to be aware of the issue of IP ownership. Make sure you have access to IP, either owning it or having licenses, and find out what your university's policy is here, what your investors' policy is here, and get a deal, an IP transfer deal that suits your business case. So we're already coming to a close and to our conclusions. Here's the pitfalls, 5 biggest pitfalls we have collected for you here. The first one we want to mention is your competitor sues you for infringement and you have no own patents to assert in return. So as we've mentioned earlier, you need an own patent or IP portfolio, and keep in mind, offense is the best defense many times. Second pitfall here is you determine on product, technology, and brand design before avoidable IP issues pop up. A classic example we've seen a lot is startup decides on a brand name and just later finds out that this is already protected by a third-party trademark. That, of course, is an avoidable IP issue. Trademark freedom to operate search is not very complicated. Get this done before. The third one is the race against time we've mentioned earlier. Make sure you're faster than your competitors and faster than your own researchers' publications. Number 4, you think your know-how protection is sufficient, and then an employee leaves on bad terms or your IT systems get hacked. As we've mentioned, trade secret protection is not very complicated and not very expensive. Use this tool and avoid avoidable mistakes here. And lastly, R&D cooperation agreements. So of course, if you're an innovative startup, intellectual property is really the key of any cooperation, R&D cooperation agreement, to make sure the clauses are well, have this seen through by an expert. So to sum up, keep the lavender we mentioned earlier in mind. Make sure the moths don't eat up your clothing. Make sure you have IT before it's too late.
Yeah, to round up our short coffee break, 5 take-home messages for you. Well, of course, this summary is early stage IP pays off, but why does it? Because find your matching IP strategy and get proper protection. Look at the scope of protection needed as well as the geographic scope needed. The second take-home message, own your IP. Ensure the transfer of ownership from any of your collaborators, researchers, PhD students, and so on. Third point, a proper FTO saves your business model. Fourth point, start early, as mentioned, and have the right people for IP advice, be it internal people or an external advisor, and also think of international protection and whether you need international experts. Last but not least, plan enough money and enough budget for your IP strategy, and also use IP to acquire funding. So we've now come to an end of what we prepared for you. Are there any questions or discussion points? One question was whether we share the slides after the event. Of course we do. And should you have any questions later coming up, please do not hesitate to contact us by email, telephone, whatever. And finally, we would like to draw your attention, just checking the chat, but no further questions. Last but not least, I would like to draw your attention to our next coffee break session, the third one, held by our colleague Niklas von Woodke, and he will give you tips and tricks for your financing round on March 21st. So you can already now register if you want. Thank you very much for having joined us today. And as mentioned, if you have any questions, don't hesitate to contact us. Thank you.
Thank you and goodbye.